Thom Hartmann here with you. Christopher Brown is on the line with us, the principal attorney with the Brown Firm, PLLC. BrownFirmPLLC.com is the website, and you can tweet Christopher Brown, Attorney Brown, at ATTYC Brown. Attorney Brown, Christopher Brown, welcome to the program. Please tell us, what is qualified immunity? I understand New York ended it for police last week. Give us the details.
Tom, how are you? It is such a pleasure to be on your show.
Thank you so much for joining us.
Yeah, as a matter of full disclosure, I saw you on Rising with Crystal and Sagar a couple months ago, and you were talking about your book, The History of the American Oligarchy. And that was one of those rare occasions where after the show, I went and bought your book right after I saw it. So fabulous. Huge fan. Very excited to be on your show. So qualified immunity. Let's start off by saying that qualified immunity is going to go down as one of the, I think, most regrettable actions by the United States Supreme Court. So contextually, let's talk about this. In 1864, the Civil Rights Act was passed. In 1971, what is referred to as the Ku Klux Klan Act was passed. 42 U.S.C. Section 1983. It was passed because of commingling between Ku Klux Klan members and state actors in terrorizing African Americans to protect them from the actions of people acting under the color of the state, authority of the state.
This was 1871, right?
1871. Sorry, yes.
Right.
7 years after the Civil Rights Act, so 1871.
Yeah. Not
much happened with it for about 100 years. And then in 1967, the United States Supreme Court decided, we know you wrote this statute that said you could sue state actors, but you must have meant that there was going to be some level of immunity for these actors. So we're going to impose a doctrine called qualified immunity. And what qualified immunity does is it changes the game when you're suing police officers. Now, understand, it's for suing any state actor. So an example I like to use is this. If a teacher locked a student in a classroom because they were in trouble and they had to stay after class for detention and forgot the student was there and left them overnight, the student's family would sue, right? That teacher would be held to a certain standard, maybe entitled to qualified immunity. It wasn't a clearly established right. What's always puzzled me about qualified immunity is there is zero consideration given for the fact that these officers are trained professionals. So they're treated like kids, like 12-year-olds. If we went through some examples of where qualified immunity was granted because the right wasn't clearly established, we're talking about an officer who was warned that a suspect was doused in gasoline, but nonetheless tased the suspect, and the suspect caught on fire. Well, granted qualified immunity because it wasn't clearly established. An officer tasing a suspect for jaywalking. Well, that had never happened before, so that right wasn't clearly established. Shooting a woman several times, standing in her yard, holding a knife, and doing nothing illegal. That had never happened before because her roommate was next to her, and the officer was concerned, as he claimed, she may stab her roommate. So it's become a shield used by officers to protect them from anything but the most egregious, willful, and wanton sort of completely lack of any sense of reasonableness. Beyond that, they use this and they get off the hook time and time again.
Now, my understanding, thank you, Christopher Brown. I did not know this. I did not know that this came out of a Supreme Court decision, that this was court-made law as opposed to, or judge-made law as opposed to legislature-made law. I had assumed that there was a law that identified qualified immunity, and in fact, I had always believed that it only applied to police, that firefighters and paramedics did not have qualified immunity. It sounds to me like any government employee of any kind of any level of government has a certain level of qualified immunity. Just confirm that for me. And how is that different from sovereign immunity? That is our inability to, for example, sue a legislator for doing something, stupid, or sue the president for doing something that causes the death of people. Trump's immigration policies, putting children in cages, and 7 of them died. My understanding is he can't be sued for that because he was acting on behalf of the state as the sovereign.
Well, that's what the Supreme Court was trying to do in Pearson v. Ray in 1967. They were essentially saying the legislature didn't say anything about immunity in the statute, but, we need to balance this with the idea of sovereign immunity. So we're going to put in this qualified immunity, kind of a middle ground. So sovereign immunity is a beautiful thing. You can't sue the king, right? And that's been passed down for centuries. But immunity can be waived. And you can sue a police officer who crashes into your car. You can sue a police officer if there's certain things where states and municipalities waive immunity, allow you to sue for negligence and things of that nature. The difference is when you're suing a police officer for hitting your car, just in a regular old car accident, it's a negligence standard, and the jury's going to decide whether it's more likely than not that he was at fault. When you get to an excessive force claim under 42 U.S.C. 1983, the qualified immunity kicks in when you're claiming that they've deprived you of some constitutional right. And that's when all of a sudden you have this two-pronged test. One, was the action a deprivation of the individual's constitutional right? And 2, was that right clearly established at the time it took place? And I don't inherently have a problem with that, Tom. I can work with qualified immunity. The problem comes in where the court interprets, was the right clearly established? And where they've interpreted that is by saying, we need to know, was there a previous case that discussed this behavior that put the officer on notice this would have been unlawful? Now, do we need precedent to tell us you can't tase a jaywalker? Do we need precedent to tell us not to tase a man who's doused in gasoline? Do we need precedent to tell us you can't stick a dog on someone who's already surrendered and put their hands up? And this is the problem. They look at the case law and they say, no, we haven't seen a case like that, qualified immunity granted.
We're talking with Christopher Brown, principal attorney at the Brown Firm PLLC, the website brownfirmplc.com, and the Twitter handle @ATTYCBrown. Attorney Brown, we have a minute and a half here before we're going to run head on into a hard break. What do we do about this? It seems like it's being wildly and widely abused.
That's an understatement. A lot of things are happening. States are removing qualified immunity as a defense to their state law claims. There's a problem with that, though. Like Maryland, there's no qualified immunity. Colorado passed it last year, got rid of qualified immunity. New York was the first municipality to get rid of qualified immunity, which is what we're talking about. Although you have 54 civic organizations writing letters to the state legislature saying this is nowhere near enough. Just because you're going to tag on this qualified immunity defense that's getting knocked out doesn't do anything to address the funding issues, the bloated funding, the fact that the police are still involved in mental health crises, et cetera. Nonetheless, it's a step in the right direction. What can we do? The Supreme Court's not going to do it. It's not going to happen anytime soon. We need to get our Congress and the Senate to get rid of the defense of qualified immunity, and they need to basically come out and blatantly say, we didn't put it in the statute when we wrote the statute, and we don't want it in there imposed by the court. And that's exactly what happened. The court wrote this immunity doctrine into the statute to protect police officers.